like that, bring that right here, sit that right there, don't go nowhere, little baby gon' shake that, 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 yeah, I like that, bring that right here, sit.
Today we are reacting to Times Idiot Cops Got Owned in Court. This is by Enforced.
I'm asking all this so that I have the opportunity to watch my son graduate from high school. My daughter is getting married so that I can be there for her. And my wife so that I can be a husband that I haven't been in 25 years due to my career. I've just not been there. I worked for professionally and honorably for 25 years was stripped of me. There's no way to blame but myself.
Dirty cops.
Is he trying to accept some type of accountability?
Cops are a menace to the public. Today, we are going to see how these cops are put back in their place in the courts. These cops failed to produce their defense in court, get brutally owned, and have to pay for their crimes. Welcome to Pike County, Ohio, where Judge Patricia A. Cosgrove is about to give verdict in trial of former Pike County Sheriff Charles Reeder. He has been indicted on 18
counts. Damn.
counts, including theft in office, tampering with evidence, and racketeering. The courtroom hears in silence as the judge tears down Sheriff Reeder's corrupt tenure.
Be seated, folks. We are here today for sentencing in the case State of Ohio versus Charles Reeder.
Sheriff Reeder, while sobbing, gives out a long testimony, pledging for leniency.
Huh? No. No.
I stand here before you today.
Hold up. Let me turn that up a little bit.
Take accountability for my actions. As a sheriff of Ohio, I should have light on the office of sheriff. I can only ask that my staff, their families, the community, and my family who is here today will forgive me for the undue stress I caused them. For this, I'm terribly sorry.
Was you sorry when you was committing the crimes? That's my thing. Like, bruh, you ain't feel no guilt when you was doing it. Now you want people to be like, yeah, bruh, feel sorry for me, bruh, because I'm apologizing.
I stood in this court on September 24th and pled guilty to the charges against me. To accept responsibility for my conduct.
Boss, you had no choice. I mean, it would have been worse if you would have said, yeah, bro, not guilty.
That day, within minutes, everything that I've worked for professionally and honorably for 25 years was stripped of me.
And honorably, I don't think you know what the word honorably means. Like what? No, you didn't.
With nobody to blame but myself. My staff and I had united with the community and had a partnership and trust. If they truly believed in us as a unit, as a whole, and had to create that trust. If I could go back and change it, I would a million times.
Sheriff Reeder begs the judge,
Or you could have just not did it in the first place. That was always an option.
for another opportunity at life, since he is greatly remorseful and wants to mend ties with his family. He also begs the judge not to send him to prison since his father has COVID-19 and is battling for his life in Columbus, but the judge seems unmoved.
I am a good person who made bad decisions and choices. I can continue to be a productive citizen in this county and be in the community.
When there's nothing holding you back, what would your thing be?
The cannabis industry is exploding nationwide, and that's why I created the Master Mentors Live educational
Bro, I keep seeing this ad again. If you are not handing out the product, I do not want to participate.
platform to train, prepare, and
Give me that.
mentor entrepreneurs that'll be
Bro,
in
they
the
dropped
right
me off a
place at the
bag.
right time.
With the love that I have for my family, my friends, and my neighbors. I'm asking all this so that I have the opportunity to watch my son graduate from high school and attend college this year. My daughter,
She looking like, well, that ain't gonna happen.
he's getting married in October, so that I can be there for her. And my wife, so that I can be a husband that I haven't been in 25 years due to my career. I've just not been there.
She like, that sound like a you problem.
Given the opportunity, I would be able to spend the time with my mother and my father and continue to be there for them when they need me. In the last years of their lives, as I've experienced this week with my dad, when 2 days ago I thought that I had lost him.
The judge then asks Sheriff Reeder why he committed those crimes in the first place.
Thank you.
To this, Reeder replies that he took the money from drug dealers, the bad guys. Reeder tries to persuade the court he is like Robin Hood, stealing from the rich drug dealers to give back to
What?
the community.
The big question I have, and is on everyone's mind, I'm assuming, is why did you cut open these evidence envelopes and take the money out, and then in some cases you put it back, although you were caught because the envelopes had been unsealed and sealed again improperly, and the denominations did not match what was taken at the crime scene or from those individuals. I guess, why did you take the money?
I took the money, and mind you, this does not excuse it, but from drug dealers
Okay.
that took it from parents of very poor people in this county. That money, regardless of what the state and what the media has claimed in the past years of a gambling problem and that money being used for gambling, was used when there was a tree planted in the name of the Shelton boy. It's at the entrance of Western High School to the left as soon as you pull in. Nobody could pay for that tree. Nobody offered to pay for that tree. A drug dealer did. When schools had cheerleading or pee-wee that had car washes and such, I would have our cruisers take it down there. My men and women did not make good money, so some of them would give them $2, $5. I took money from that, and I provided it to those people.
The judge then
Okay.
gives Sheriff Reeder and the courtroom a piece of her mind. She begins to remind Sheriff Reeder of all the suffering his corruption has caused to the people of this county.
Here's what I want to say. You've been in law enforcement for 24 years. Whether you are a sheriff, whether or not you're a sheriff's deputy, whether or not you're a prosecutor, whether or not you're a defense attorney, or whether or not you're a judge, you choose to be in this profession. We see horrible things, multiple deaths as you have, deaths of babies, torture of old people. This court personally has had to sentence a number of people to death, impose the death penalty. We all choose our profession, and we have to conduct ourselves with integrity so that everyone trusts us. Now, no person is good or bad, but you had an obligation, Mr. Reeder. The sheriff's office, like every other PERS entity, has a free counseling program. In other words, you could have sought free counseling at any point in time for your conduct. It cannot be underestimated the damage that you have caused to the citizens of Pike County, to law enforcement who every day get up, face the same sort of stresses that you do. They go all home at night, they get up in the morning, their family, they don't know if they're going to come home. The sacrifices that these men and women make, I think you made a mockery of them. I could have imposed a much greater sentence than I have.
What is the sentence?
As I said, I've taken into consideration some of the mitigating factors, but punishment is appropriate. To sentence you to, I consider the minimum. However, to sentence you to anything less than 3 years in prison would demean.
That's it. It's only three years in prison. But how much money did he make off of these drug dealers?
The seriousness of the offense and not adequately protect society from future criminal conduct by yourself and others.
Reeder was sentenced to 3.5 years in lockup after taking
That's it.
a plea deal related to theft and corruption charges in 2021 while he was sheriff in the small county. Reeder pleaded guilty to 2 counts of theft in office, 2 counts of tampering with evidence, and 1 count of conflict of interest. Next, we journey to Seminole County, Florida, where a courtroom drama is about to unfold. Judge Fred Schott is on the brink of a fiery confrontation with the prosecutor over an unjust arrest, which happened due to arresting Officer Michael Wagner's mistake. The individual at the center of this controversy is Lysette Gonzalez, accused of a DUI. However, it seems that Officer Wagner neglected to administer a breathalyzer test, yet arbitrarily noted in his report that Gonzalez tested above the legal limit of 0.8. On the basis of this DUI, 2 months later, Gonzalez was arrested and had her license suspended. The judge proceeds to ask the prosecutor and the cop, how is this license suspension valid, since the first DUI charge that started this case was not justified.
You have this other case for driving while license suspended, and
yes, I actually was, if I could be heard on that matter, I was going to ask.
Before you go there, I want to be enlightened. I didn't think your license got suspended for 6 months just for getting arrested for a DUI.
It was a mistake, admittedly, by Michael Wagner.
I know.
Testified to that today.
He caused her to have her driver's license suspended for at least a few months, and now you're arrested.
Yes, he did, Your Honor.
For nothing.
Judge Schott is furious at Officer Wagner as he thinks that the officer committed perjury and inquires the public prosecutor if the government will take Officer Wagner up for perjury. The public prosecutor continues to defend the lies of Officer Wagner.
What?
You're going to know across that case, I'm not going to get mad at you today.
Perhaps you can get mad at me, Your Honor, but at this point,
Wait a
the only
minute.
thing that we're willing
Did you
to
hear
do,
the
Your Honor,
uncontroverted testimony of this officer?
Your Honor,
Yeah.
regardless of...
Tell me your position.
Yes, Your Honor. The DMV is in charge of suspending licenses.
Yeah,
They
when
received this
officers
information-
lie to them.
Correct, Your Honor, and that's why patrons...
Then I want you taking him up
Your
on
Honor,
perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied
I mean, he lied. I don't know what to tell you.
on a sworn
Absolutely not,
citation.
Your Honor.
Judge has had enough
Absolutely not. Oh, you're cooked.
of it, and he dismisses Ms. Gonzalez's sentence sua sponte, which means he has enough reasons to believe that the jury was misled by the evidence turned in by Officer Wagner, and therefore he is overturning the jury's guilty verdict.
And that is
That's
not
the first time I heard of that.
true.
I'm
The state's
dismissing. I'm
position,
dismissing.
you cannot summarily dismiss, Your Honor, without a motion for us to be able to respond to.
No, I'm dismissing the charge. You can appeal.
We will, Your Honor. Please provide us a written order.
No, I'm dismissing the charge.
So there will be no
Sua sponte.
court minutes or
Sua
whatsoever.
sponte, based upon
You thought you was gonna get paid?
this record. And that case has the same record as this case. So take it up on appeal with him lying about it and getting
It's
her
not lying, Your
license
Honor,
suspended.
He's not lying, but he did lie though.
And I won't let that be said today. He admitted to the mistake today. Patrons and people who have
This whole case
identifications and
was
driver's licenses
fishy.
in the
Judge berates the public
Yeah, go ahead, cook up, Judge.
prosecutor for
You've been in your bag all day.
shamefully defending Officer Wagner, and declares that the arrest for a DUI, as well as the subsequent arrest for driving on a suspended license, were illegal.
You know what?
state intends to amend the charge
granting-
and proceed on
I
a no
am,
valid.
I'm rescinding the sentence. I'm granting the JOA.
So you're granting it because you don't agree with the state's decision on
I'm
the other
granting
charge.
JOA in fairness.
In fairness, because you
Yeah.
don't like the state's decision today, Your Honor, on the case?
No, you're not. No,
Let
I've
me be heard.
reconsidered all of the testimony and the evidence. And you know, now
And the
that I
state would like to be heard on
now
that
that I
matter.
consider what Officer Wagner testified to and how many times he basically tripped over himself unnecessarily just to arrest this lady with no real probable cause. We should have had a suppression hearing. I'm granting the motion for
Then
JOA.
the state would like to be heard on that matter, Your Honor, as they're entitled to be heard.
Sure.
Judge not only dismisses the charge, but he also vows to bring Officer Wagner and others responsible for this gross misconduct back in court where they will be held accountable.
Today we've proven, as Your Honor initially indicated, until such time as the state was not able to tell you why we were proceeding on the charge that we were proceeding on, the state intended to amend that to either a civil infraction and or a no valid, but the state needed time and intended to do that. However, in this particular case, there was ample testimony as to the fact that the defendant's own statement that she was in possession of alcohol and she drank it. There was testimony uncontroverted from the defendant that was in fact alcohol and she normally doesn't. This is again evidence, direct evidence, and not circumstantial evidence. Furthermore,
He like, yeah, you can keep talking, but I don't care.
there was bad decision making, there was balance, there was sway issues, and everything else.
JOA for the defendant. You're done. They still have this other criminal charge, so I'm not dismissing that. The DeWillis, we're going to go full bore. We'll get DMV people in here. We'll get Officer Wagner back here, and we'll find out why your license was suspended or somebody broke the law to cause your license to be suspended. And that's the route you wanted to go.
No, Your Honor, that's not the route.
Is that a third?
Motion, the JOA is granted.
The judge criticizes the criminal mistake of the cop, Michael Wagner, and orders the motion to be dismissed. Gonzalez was released soon afterward. Next up, we have Prosecutor Larry Foreman, who is interrogating the arresting officer in charge of the DUI case against Mr. Dawson. The cop admits under oath that he poured out the alcohol found at the scene, thereby destroying a key proof of Mr. Dawson's wrongdoing. Arresting officer,
Wait, what?
the cop, Michael Wagner, and orders the motion to be dismissed. Gonzalez was released soon afterward. Next up, we have Prosecutor Larry Foreman, who is interrogating the arresting officer in charge of the DUI case against Mr. Dawson. The cop admits under oath that he poured out the alcohol found at the scene, thereby destroying a key proof of
What?
Mr. Dawson's wrongdoing. This does not go well with the prosecutor, who then proceeds to school the cop on what the law says.
Okay, so I want to talk about, very briefly, about two things. Number one, I want to talk about the alcohol that you found in the Wendy's cup in the car. Correct?
Yes, sir.
You found it after you had placed Mr. Dawson in handcuffs, correct?
That's correct.
He was already under arrest before you found that cup.
That's correct.
You testified on direct examination that you sniffed the contents and determined it to be alcohol, correct?
It had the odor of an alcoholic beverage.
It had the odor of an alcoholic beverage.
Yes.
Did you bring it with you to court today?
What?
No.
Did you preserve it in the evidence locker at the Richmond Police Department?
No, I poured it out.
What? Why?
Are you admitting to this jury that you committed the offense of destruction of evidence?
The public prosecutor seems shocked as he realizes that the officer had
Why would you destroy the evidence, you dimwit?
admitted to a felony under oath in the courtroom. The cop also realizes his mistake and takes a pause before carefully choosing his next
You're cooked.
words so that he does not incriminate himself again.
I did pour out the liquid that was in the cup. I had no plans on collecting it.
Why would you not collect evidence?
It's not our common procedure or policy that we do collect those at the Richmond Police Department. So I smelled what I believe to be the odor of alcoholic beverage, and based on Mr. Dawson's statements as well. And I poured it out. Yes, sir.
When the lawyer asks the cop what he did when he saw the alcohol
Why did you just have that elongated ass sentence to tell them that, yes, what you just said was true? I destroyed evidence.
beverage in Mr. Dawson's car, the cop naively tells the court that he poured it out.
Are you aware that destruction of evidence is a Class D felony in Kentucky, carrying up to 5 years in
Wow.
prison and a $10,000 fine?
Yes, sir.
Let's talk about the marijuana. You searched the vehicle and you did not find any marijuana, otherwise you would have charged Mr. Dawson with possession of marijuana, right?
That's correct.
The defendant was released following this trial, and the cop learned a lesson on how not to talk in court. For our final Cops Got Owned clip, we head to Oconee County Detention Center, South Carolina, where things are about to get heated. Deputy Underwood was arrested after barricading himself in a building where police had arrived to throw him out after an eviction notice.
What?
He threatened that he had a gun. Later, after a peaceful negotiation, he surrendered but was later charged with resisting arrest. In this footage, his lawyer is trying to get him out on a bond, but the officer's attitude is making it difficult.
I'd like to hear from the Solicitor's Office and the Sheriff's Department before making any decisions regarding bond for Mr. Underwood.
Yes, sir. May it please the court, Judge, just to clear up any issues regarding the warrant, the warrant is resisting arrest. However, I think what Mr. Underwood's maybe misunderstanding about that is that the resisting arrest also encompasses resisting the service of process or a writ. That is the specific portion that is being dealt with in this particular case. This situation arose when representatives from the sheriff's office went out to the residence where Mr. Underwood was staying and attempted to serve him with paperwork for an eviction. Mr. Underwood refused to accept that paperwork, so at that point, officers came back, obtained that warrant, and went back to serve that warrant. So that's how we got to where we are with regard to the warrant.
The prosecutor is trying to...
Well, he could be an auctioneer. That man just talked fast as hell. What?
clear up any issues regarding the warrant for Mr. Underwood's arrest. He says that Mr. Underwood only refused to comply with the arresting officers because he thought they didn't have an arrest warrant but an eviction notice. But he complied when the officers went back and obtained the correct warrant. He then tells the court about what the conditions that would come with the bond, such as an ankle monitor and prohibiting him from going near his ex-wife.
Living with him at that residence, and I believe the primary person at that residence is the mother of Mr. Underwood's child. I don't believe they're married, but they do have a child in common. Certain statements were made while the situation was going on yesterday with regard to the standoff. A gun was obtained by law enforcement.
Hey, bro, there is no way somebody's phone is going off in court, bro. What the hell?
At the time of the arrest, Mr. Underwood did say that was his weapon and intimated to officers that it was not for use on officers, but it was
intimated. Is that how you use that word?
For use on his child's mother. Given those circumstances, there was also some marijuana in the residence that was turned over to narcotics as well at the time of the arrest.
Yeah, we was hoping we can get that back. No, we can't get that back.
I don't know that any charges have been made with regard to those drugs. That's something that we'll be dealing with at a later date. But for today's purpose, what the state would be asking for is a cash or surety bond. We would request a bond of approximately $50,000. And we also believe that based upon the statements that Mr. Underwood has made, intimating potential harm towards his child's mother, we believe that GPS monitoring, ankle monitor is appropriate in this case. We would also ask that the bond specifically include provisions prohibiting him from going to her place of work and to her residence. And certainly we can furnish the addresses to the monitoring companies so they can go ahead and plug that into the monitor so they'll be notified if Mr. Underwood goes to either of those places. I think that's all we're asking for today. Any other issues certainly can be taken up at a preliminary hearing or at the appropriate time later on.
Okay.
The judge proceeds to accept the conditions set forward by the prosecution lawyer, but not before Officer Underwood shows his arrogant attitude.
Thank you.
Thank you.
Officer McCreary?
I really don't have anything else to add to what he said.
Nothing to add?
No, sir.
Okay, thank you very much.
Wait, so that's bruh? What is he doing? He ain't did nothing yet. He been sitting still the whole time. Looking ugly as hell, but...
All right, Mr. Underwood, I find the solicitor's request for a cash or surety bond of $50,000 to be reasonable accordingly. I'm going to impose that cash or bond for your release.
I find it absurd that you haven't even obtained any information from me based off the solicitor. You're going to believe everything he says.
Okay.
And you're going to set a surety bond on me on a misdemeanor.
Okay.
Damn, it's a misdemeanor?
Are you finished? Okay, if you'll hear me out, please. Thank you. Additionally, I'm going to place a requirement for a GPS monitor prior to your release on bond. I'm going to restrain or restrict your contact with your domestic partner or the mother of your child, whichever best describes her, to include her place of work and her residence. Additionally, I'm going to prohibit your physical or constructive possession of firearms or ammunition at any time for any reason. And I want to make sure that you understand, when I say constructive possession, I mean there's to be no firearms or ammunition in any vehicle you're being transported in or riding in unless it's...
What grounds? Are you prohibiting me from firearms?
I am.
Why? What grounds?
I am. Because I have that latitude given the severity of...
What reason is your
Sir.
why are you standing behind it that you're gonna
Mr. Underwood,
firearms?
Mr. Underwood, in this...
What? I don't know. That sentence was trash. That is a trash sentence.
In this court, one person talks at a time.
From the solicitor's office and the sheriff's office.
You're going to find yourself in contempt of court.
I've already been in contempt.
Okay.
I'm not here, sir.
I mean, you can get contempt again. It's just more fines.
All right. Are you going to allow me to finish? Constructive possession of firearms or ammunition. means you will not have it in your possession. It won't be in the house or the room that you're staying in. It won't be in the vehicle that you're being transported in, unless we're talking about transport by law enforcement. Do you understand that? All right. That's all. You're dismissed. Officer, if you'll remove him.
You can't look at it, can you? You can't look at it, can you?
He hot. Like, bro, you need to be mad at yourself, bro. I mean, this is a good little video. Yeah, that's my time. I'll catch you on the next one.
To live is the content, ayy. How this pain got me feeling accomplished. Can't turn me to a monster, ayy. My God mode can't stop me. To live is the content, ayy. All this pain got me feeling accomplished. See, this game turn me into a monster, ayy. I'm a God mode can't stop me, ayy. To live is the content, ayy. All this pain got me feeling accomplished.